Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast hosts, we try to bring our audience of trial and appellate attorneys some legal news and perspectives they can use in their practice. As always, if you find this podcast helpful, please recommend it to a colleague.
And do give us a helpful rating on Apple Podcasts or wherever you listen to this podcast.
Today, we're very pleased to welcome Patrick Hagen to the podcast. He's someone who has become something of a legal writing whisperer on LinkedIn. Patrick is an accomplished attorney with deep experience in complex litigation, but what truly sets him apart is his uncanny ability to make legal writing both sharper and more human. With over 35,000 followers on LinkedIn, Patrick has built a devoted audience of lawyers, law students, and just legal nerds everywhere who tune in for crisp, clever, and often disarmingly generous writing tips. And for our purposes, Jeff, we hope to tap into some of Patrick's 35,000 listeners. Or I think that was the last time I checked. By now, it might be up to 40 or 50,000. Who knows? It's growing.
Yeah.
It's growing
now,
daily.
Tim, I have a quick disclaimer. They're mainly bots, but I have a few real lawyers as well.
All right. Yeah. We have a few, maybe the same few real listeners to this podcast. But to finish your introduction, Patrick, you've served as editor-in-chief of the Regent University Law Review. You clerked in federal court, and now you practice law in Utah, while maybe moonlighting as the internet's favorite legal writing coach. So today we'll talk about where your love of writing began and what fuels your relentless clarity, and what really happens when you spot a grammatical faux pas in the wild. Do you really react with such earnest and charm, or do you sometimes grate your teeth and bang the table when you see the same legal errors over and over again? So welcome to the show, Patrick. Thank you for joining us.
Thanks. And just a quick clarification, I practice in Florida, but with a national firm. So I get the pleasure of working on cases nationally. Haven't had a Utah case yet, but I know Charisse on LinkedIn. She's our Utah expert.
Yeah, see, here's a good live example of why not to trust ChatGPT for everything. I fed it a bunch of information about you, and it came back with Utah, and I thought, well, I didn't think Utah. I should have checked that. But yeah,
so as you can see here, I'm in Florida's capital, Tallahassee. That's that large building behind me.
That's
I don't know
right.
what the Utah Capitol looks like, but.
Well, Patrick, let's get right into your, you built a reputation for legal writing advice that's both creative, enthusiastic. You've got 36 plus thousand LinkedIn followers, and they can't all be wrong. So walk us through your process from identifying a common writing pitfall to delivering a post that really sticks in people's minds.
Yeah, for me, my legal writing journey on LinkedIn started about 3 years ago. And I think at the time I was following
Lindsay
y'all probably follow as well, Lindsay
Lawton.
Lindsay Lawton. She used to practice here in Tallahassee. Now she's an administrative law judge. And so Lindsay started posting legal writing tips. And I thought, as someone who used to be an EIC and just did a few years of clerking, what could I give back to the legal community? I can't really be an expert on a lot, but I thought, hey, I have some legal writing advice. So I started jumping in. And I remember one of the first posts that I ever made, Ross Guberman reposted it. And I was like, I have this guy's book. He spoke at the courthouse. He signed my book on legal writing. I'm like, okay, I have to keep doing this. And so for me, it really just started off by noticing things I saw in other briefs and things that I know judges thought were not great writing styles and things that would upset judges or just not be as persuasive. And that's what all got it started for me.
Yeah. Well, your tone on LinkedIn in presenting all of these legal writing tips, it's always in sincere earnest and helpfulness. What part of you and your personality is behind that? Because what I've seen, there may be multiple. Obviously, all of us legal writing nerds come in different shapes and sizes, but a lot of us can be very mean when we spot a legal writing faux pas.
Yeah.
I remember reading one fun tweet online. This wasn't in the writing community; it was in the programming community. But it was someone who said, "Whenever I have a programming problem that I can't get around, I'll post it on Reddit, And because I know people are not naturally helpful, but they are naturally mean and biting and want to correct errors,
Hmm.
I'll log in under a different account and make an obscenely wrong answer to my own post. And then people will jump on and I get the right answer 100% of the time. So
That's
well,
right.
I guess that's another way. Maybe I just thought of my own way to break into the legal writing tip community. Uh, but
Yeah. Post bad
uh,
tips on Reddit. See where it
yeah, that's
goes.
right. But how do you what's the origin for each of your tips and how you come across them, how you present them with such charity?
Yeah, as for my style, it comes down to personality. I found that on LinkedIn, just as in anything, you want to be authentic. And so I'm not a type of person who's angry about stuff or gets super passionate about stuff where I'm just going to be like, this is the only way. Um, Maybe except for my old days of wanting two spaces after a period, but we can talk about that later. So yeah, I remember when I first started litigating, a partner was like, if you're not an intense personality who really loves to argue and is just gets passionate about stuff, and you can't really advocate for your client knowing that they're the only right way, then you can't be a litigator. And I learned pretty quickly that judges don't think that way. Judges are very neutral and they see both sides. But with LinkedIn, of course, you have to pick a side, just like with arguments representing clients. And once you pick a side, you're going to get a whole host of people who pick the opposite side. And that's what really drives a lot of posts. But for me personally, I like to be authentic. I like to be kind. And most of the time in legal writing, there's not always a wrong way. But in my opinion, there are some wrong ways. But that sums it up.
There's always, yeah, different schools of thought, I guess
That's right.
you
Yeah.
could put it. Even the people who don't embrace the Oxford comma, I guess they're still in good company. They still have reputable people. You know, they, they could still we could still allow them to have a career. We could say we
There
can
are
allow them
there
to
are
exist.
there are a few Oxford comma users that I work with, non-Oxford comma users, and that's one thing I just want to edit so badly. But since they're the senior attorney who's been practicing for 40 years, I just have to grit my teeth and let it go.
Are there any experiences that you've had in your life and career that were really formative in developing your approaches and ideas about legal writing? You've been an editor in chief of Law Review. You've been a judicial clerk, and now in practice. Are each of those experiences, do each of those experiences lend to your body of knowledge and opinions on legal writing? And are there other checkpoints that were formative?
Definitely, I started off clerking for a state appellate judge who his whole writing style was not like what I saw in law school, which was convoluted and thick writing style. What I learned from this judge, his name's Tim Osterhaus, was to write clear, simple opinions that an ordinary person on the street could read and understand. And so that was his style. Then I went and clerked for a federal judge, the Northern District of Florida, Kent Wetherell, and he had a very similar style. His was break it down, simple concepts, and that really formed a lot of my writing style today that's continued on is judges want clear, simple writing, and it's easier said than done. It's hard to write clear, simple writing and still convey a very complex idea.
Now, I'm going to ask you the hard question now. I want you to admit what is an embarrassing writing faux pas that you personally have committed in the past?
Yeah, when I first started private practice after clerking, one of the faux pas I got was, look, your writing sounds like you're a judge. Like, stop writing like you're a judge. And so, personally, I was so afraid to be biased or overstate things that I'd write briefs in this hyper neutral and a judicial tone. And so that was the first lesson was this is your client. You have to advocate on their behalf. And I found somewhat of a middle ground that I don't have to have these strong words like clearly or obviously. I'm not going to put that in a brief, but you can still advocate for a client in a way that is representing them to the fullest extent you can.
Do you ever have co-authors who insert those kinds of words that you deliberately omitted? I'm not going to say clearly. I don't want to say obviously. I don't want to say axiomatically. And yet here you get a red line saying, "Oh, you need to have more emphasis."
Oh yeah, yeah, especially in my earlier days of being an associate. you don't have as much power to push back, and you probably don't have that same relationship with the partner that you're working with to really say, okay, but this is why I wouldn't go so far to include that word. But the farther I've gone along in my career, the more the more ability I have to actually work with the partners and clients. Clients is the trickier issue of saying, okay, this probably isn't something we want to put in there. I know you feel very strongly about this, but
Yeah.
something you have to think about when you're writing for a client is they know the case so personally, whether it's a business or an individual that has such strong feelings about the case because they've been hurt by it, whether it's a commercial dispute or something more personal. It's very personal to them, no matter how you view it. But then on the other side, you have the judge who sees things in a more neutral tone, who looks at both briefs. And I saw that in my time clerking. And you have to find a way to build a bridge between the two, between advocacy and neutrality, so the judge can actually see the persuasion in your argument, but at the same time not using such strong words like obviously, axiomatically, and etc.
Yeah, that can be very difficult, playing that intermediary between the client and the court.
Hmm.
Uh,
The client, the court, and Google and ChatGPT, when you have a client who said, "Hey, how about inserting this legal doctrine that doesn't exist, but ChatGPT tells me exists."
Yeah, and I
Uh,
have a whole host of cases that it gave me you should use.
yeah.
yeah.
Do you or your firm have you started toying around with using forms of AI to sharpen your writing or to give you alternative views of how a certain passage could read?
Yeah, the two non-controversial softwares that we use are one, Brief Catch.
Yeah.
I mentioned Ross Guberman earlier.
Yeah.
I'm not getting paid for this endorsement, by the way,
Yeah.
but his software has a great way of taking overused phrases and different types of writing styles that are a bit convoluted and breaking them down into simpler terms. And then I also use Clear Brief. Again, I'm not
Yeah.
being sponsored here, but I would love to be, Jackie.
Yeah.
Uh, and her software is great for actually checking cases. That's what I use it for the most, is it shows you, okay, first of all, is this a real case? And then secondly, is what you're saying actually supported? And it shows you a level of support or lack of support, because even if you're using something like a Westlaw AI, which every case is going to be real, you have opportunity to just put in what you want it to say and it's going to give you a case, but it not might not be quite as supported.
Yeah. Yeah. How about putting those two products aside, in terms of taking a paragraph of text that you've written, in terms of word choice or grammar or
Hmm.
style? Because I know Brief Catch has a series of rules that it implements from Ross's presentations over
Yeah.
the years. But, sometimes AI could be used to kind of, you can give it instructions saying, hey, make this more neutral or make this more of an advocate piece. Have you played around at all with that?
Yeah. Yeah. And
Mm.
once you do it in a way that's making sure you're maintaining client confidentiality,
Yeah.
I think it's a great tool. It's
Yeah.
it's a great way to, okay, how can I rephrase this? I think the big issue with ranging from law students to practicing attorneys is they just say, ChatGPT, write this argument for me. And then they stop there.
Yeah.
What I do
Yeah.
sometimes is I'll write an argument and then I'll say, okay, revise this sentence, make it simpler, make it something that a fifth grader could read, or let's revise this idea a little bit, using it almost more as an editing tool rather than a drafting tool.
Yeah. Yeah, and being open to iterations. It's going to
Right.
give you garbage the first time out. I've played around with Co-Counsel. Tim and I were early adopters
Hmm.
before it was gobbled up by Thomson Reuters, and it was fantastic when it was a standalone product. I don't like the interface now that it's been bought by Westlaw, but
Hmm.
the Co-Counsel component um, really can give you some outstanding first drafts that you can then, t sharpen and put in your own tone. So I've enjoyed playing around with it to a little bit, and I feel
Yeah.
a little, yeah.
We use
Um,
Co-Counsel as well, and it's all of these tools are great. You just have to recognize what are their limitations, right? And then which one is better at one task than the other,
Right.
because I don't think there's quite one tool out there with AI yet that is perfect at everything or
Yeah.
that could necessarily replace a young associate.
Yeah. Yeah, for sure. I'd say Clear Brief, they're a friend of the program, and when I'm working on appellate briefs, it's indispensable.
Yeah.
But at the trial level, yeah, co-counsel seems to be my go-to. Um, Interesting. Hey, I'm curious, does your firm have any policies or guidelines for young associates, the newcomers in terms of what they can and can't do with AI?
Yeah, the main policy is with ChatGPT
Yeah.
and making sure that associates, partners, they're not using it in a way that is breaching client confidentiality.
Yeah.
And so on one hand, we have some clients that are saying, hey, we want you to use this, cut costs, start on it as initial draft. We have other clients who say don't use it. So
Yeah.
you have to look at it from client to client, because some clients want you to use it, some clients don't want you to. And so you can't just apply a broad use of it.
Yeah. I added a provision in my form retainer agreements to highlight the AI issue so that we can float that issue early on if a client's going to have a problem with it.
Hmm.
And I don't understand why we're getting all these decisions these days with judges sanctioning lawyers for citing fake cases. Shouldn't be happening anymore. When you have a product like Westlaw or Clearbrief or any other a number of products where you can quickly in 10 seconds scan a brief and see if the cases are real or not.
Yeah.
Nobody should be getting sanctioned anymore for fake cases. It's mind blowing.
Well, it's the same lawyers who aren't taking the time to check if the cases are fake, right? But
Yeah, yeah, I
or
suppose.
it's just not getting reviewed.
Yeah. Sorry, Tim, off my soapbox. Back to you. Sorry.
Yeah. Well, and the even more surprising cases are the ones that come out of larger firms. When
Yeah,
larger firms are misusing AI, that's even more
Yeah.
mind-boggling. I can understand, the small firm or solo firm being in a rush and indulging in the ease of using ChatGPT. But you're right, Jeff. That's a good point. You could probably just use another ChatGPT search or an alternative AI search to do a final check on your brief, and maybe use that deep search tool to do a little bit more in-depth analysis. I think it's less likely to hallucinate if you use the deep search function.
yeah, I suppose.
Yeah, the big issue is depending on how you write the prompt, it's like talking to someone that is willing to accommodate your
Yeah,
request. If you write it in a certain way that says, hey, I think there's a case that says this, it's going to find a case that says that. And if it doesn't, it's going to make one up. So depending on how you write prompts, it'll really play to your needs. And I think that's where a lot of attorneys that are getting sanctioned
yeah.
are
Now,
missing.
It
let me
does
ask you
do that.
before.
Yeah.
Go ahead, Tim.
Well, on that point, I've noticed a difference between just regular Chat GPT searches, where it does, I think, what you were describing, Patrick, where it says, "Well, that's a trenchant observation, Tim. You're really on to something," and it tells me what I want to
Right.
hear. If you use the deep research tool, it doesn't do that so much. It'll ask you some
No.
follow up. Okay, do you want me to search these authorities or in this sub issue?
That's
And then
good.
it goes and spends 5 or 10 minutes to run the search, and then it comes back and it's much more neutral. There's no fluff in there telling me what a brilliant ChatGPT prompter I am and what a great question I've asked. It just tells me what I've asked it.
Right.
Uh,
So you're not using it for therapy. It sounds like that's good.
right.
Um, before we pivot away from AI, I do have one last question. You're welcome to take the fifth on this. Have you found a ChatGPT or similar products useful in terms of your LinkedIn writing, in terms of what you post on LinkedIn?
Yeah, so I didn't use ChatGPT to write one LinkedIn post till about 6 months ago. So
Yeah,
I wrote for about 2.5 years without ever touching ChatGPT. Now I'll write my posts just like I always do.
yeah,
And then I'll think of ways. One question I like to ask it is I'll put it into ChatGPT and I'll say, rate this post. Of course, it might have its own rating system that I don't agree with, or I know from experience after getting 36,000 followers that just because ChatGPT throws in some type of buzzword, it's not going to mean people are going to actually respond to it more. But it does a good job of providing feedback, and so I'll have it do that.
Oh, nice. Okay, cool.
Yeah.
It's excellent at suggesting emojis. I'd be curious to know if you use its emoji suggestion for your posts.
I
And
have
lists of
not.
three.
I need to. You're going to see my next post. It's just going to be filled with emojis because I've never asked ChatGPT for an emoji suggestion.
No, those are all original emoji you drafted by hand.
They are, yes. Typically the laughing emoji or the nervous sweat bead emoji are my go-tos.
Yeah. Well, let me ask you a little bit about your kind of, I guess, legal interpretive philosophy, or if you have a jurisprudential philosophy that guides any of your own personal legal writing. Um, as depending on the case, sometimes cases will lend to different types of approaches. If it's like a strict textual interpretation type of argument, or if it's a more of a pragmatic approach, and maybe it depends on the judge. But do you personally have an approach that you think is more persuasive? Do you usually tend to stick to what the statute says and stick to what the law says, and hope that the judge just follows the textual argument, or do you also try to make a broader, like a pragmatic or policy-based argument or a common sense type of argument as well, or do you mix it up or do all of the above?
Yeah, I have to give the classic lawyer answer. It depends.
Mhm.
But based on my background alone, I went to a small Christian law school where Scalia himself actually came and visited once. And so a lot of what we learned was, hey, textualism, the same type of stuff. Read the law as it is. Don't try to change it or bend it to work in your advantage. But sometimes, if the law is completely against you, you have to make policy arguments. And so start with textualist. And if you need to make a policy type of argument, do that. But whatever you do, make it clear, make it simple, make it something that the court can read. My one big disagreement with Scalia, though, is the length of his writing, especially the amount of Scalia opinions we had to read and how long those were. That's not my style. I try to write shorter uh, briefs that the court can actually digest.
I forget, don't the dissents tend to be longer, because you're not trying to garner any votes to join you. You're just writing for your own vanity, I guess.
That's right, and I don't think that's a luxury that we have as practicing lawyers.
Yeah. What about any philosophical stances you have, just about the writing in general, or persuasive writing? For example, should writing feel conversational? Should it, legal writing that is, should it feel more formal? And then you want to weigh in on the age-old question, should lawyers deploy pop cultural references, as more and more judges are prone to do these days?
Yeah, so taking that from the top, I'd say you need to strike a balance between the two. And it also depends again on which court am I in. Okay, if I'm in small claims court in a small county, maybe I'm more conversationalist. If I'm going up against a pro se plaintiff, maybe I'm breaking it down to be a little bit simpler than I normally would. If I'm in federal district court, it's going to be a bit more formal. If it's on appeal, maybe I'm even more formal. So I think it depends on the judge you're appearing before and the tribunal you're appearing before. But I don't take an overly conversational tone, that because I think an error that can be made when you're trying to be conversational is you see these long string sentences and just trains of thought that are just streams of consciousness, right? So I try to strike a balance between the two. And then as for making pop cultural references, both the judges I worked for, at least when I was clerking for them, they didn't take that approach. They didn't
Hmm.
try to do these like zingers in their opinions. They were about keeping it clean, keeping it simple, and writing to convey their decision, not to convey their personal opinion.
Yeah, I'd be interested in your take on what one of my own personal maxims in writing is to write the way you would speak. If you wouldn't, and speak, and when I mean speak, probably think of how you would speak during oral argument.
Yeah.
So if you wouldn't say it that way during oral argument, if you wouldn't say comes now, respondent, Joe Smith on behalf of Tim Quill, you know, then I wouldn't say that in my writing either. I want my writing to mimic how I speak, and then I want to try to up my game, my speaking game, so that I speak the way that I would be writing at my best. So I like those two to conform. So that usually means I got to bring my writing down a notch or two in terms of formality and fussiness, and bring my speaking up a notch or two in terms of, how how well I put a sentence together.
Yeah, that's a great
They're
point.
equally hard, but I wonder what your thoughts on that are.
Words are hard. Yeah. No, I
Words
agree.
are hard.
I agree with you. That's one thing that every time I write a brief, a lot of the clients that I have, they're in-house counsel clients, they come from an older background of you always put comes now. And so that's something that I just kind of, all right, I put it in the brief. So now you know, Tim, I'm not going to say it when I'm presenting before the judge, but a lot of my briefs do contain comes now, even though I hold deeply personal beliefs about it that I agree with you. We don't need uh, wherefore or for the following reasons, henceforth, forevermore.
Yeah.
I completely agree with you.
Yeah. Yeah. Well, speaking of that, I see, and this is a different subject, I guess, but in a conclusion of a brief, they seem too often to be totally wasted real estate. Conclusion is a time where you should be able to kind of kick up your feet and look, I put all my arguments out there, all the facts, all the arguments are out there. I've covered everything. Now I can just, now it's just you and me, Judge. Now I can tell you what I really think you should do with this case. And you can be a little bit more informal. But instead, too often you just see, for the above referenced reasons, the court should affirm or the court should grant the motion or whatever it is, without actually using it to say anything.
Yeah, no, that's a great point. We recently won a case on summary judgment, so woohoo. And thinking about that brief, I remember putting in the conclusion, not just your simple for the foregoing reasons, which foregoing, like who says that? Instead, I wrote a simple description of what happened in the case, which it was a case involving an accident of sorts. I'm not going to get into that, but I wrote it in a very clear manner that really struck the court so they could remember why my client wasn't at fault in that case. And I made it more of a storyline rather than just for the foregoing reasons, right?
Mm-hmm. Yeah, I think that's a great use of it. Is just to tell the story again. I think well, I remember Myron Moskovitz, who's a very prominent appellate attorney here in California. He put it once that you should be thinking about your oral argument and what you're going to be saying at oral argument. Well, as early as possible when you're writing your opening brief. And I think he likes to try to connect the conclusion of his opening brief to what he's going to say at oral argument. So you should have the theme of your case well in mind when you're writing your opening brief or when you're writing your motion, and be able to link that in so there's continuity and consistency between all of your arguments, between the time you write it and the time you get to oral argument. There's too many judges or litigants will not even remember what they were what they said in their complaint. For example, I was listening to a judge panel yesterday who was saying something to the effect of, look, when we're at a trial setting conference or at a case management conference, and I ask you, look like you alleged X in your complaint, and the attorney says either, well, I don't have my complaint here with me, or I wrote that a long time ago, Your Honor. That's not an acceptable answer. There has to be continuity and consistency of your arguments throughout the case.
Yeah, and speaking of complaints, one area you don't see quite as much storytelling and advocacy is often in the complaint. It's, all right, I need to check the boxes to make sure I hit all the elements, which of course you do, but complaints could be written a lot more persuasively by using the theme all the way throughout the complaint while weaving in the things you need to check the boxes on, but really hitting on the storyline so the judge has a little bit more vested interest in it.
Yeah, and it can be very difficult to know what your theory is, theory of the case is at the time you're writing the complaint. You're just trying to put together viable causes of action.
And in the short time frame you have,
yeah, you're trying to beat a statute of limitation or whatever it is. And you don't know what the theme is, or what the nuance, the factual nuances. You haven't had the opportunity for discovery yet. So I would, grant allowances to the trial counsel between the time of writing the complaint and the time of trial. But judges often don't. They look at that operative complaint, whatever it is, and they're going to hold you to it. So maybe if there have been substantial changes in the case and you want to update what your legal theories are or the factual theories, maybe consider amending that complaint before you show up to trial, and the court says, "Did I call the right case? This doesn't seem like the case that I read in the based on the complaint."
Yeah.
I wanted to go over some of my favorite of your writing tips, or another way to
I,
put them.
I'm excited because it's been some of them I wrote like years ago, so
Yeah,
I'm ready to hear them.
yeah, or to put it in a negative connotation, writing tips or pet peeves.
Yeah.
So here are some of mine that you've written in the past. Be ruthless with transitions. Guide the reader logically. Now these are just very short. It's
Hmm.
lacking the context from your original quote, but if you or post, but if you can remember what you meant by that, being ruthless with transitions because they guide the reader logically. What do you mean by that?
Yeah, that point goes back to a professor I had in college where he said, okay, so you can read this whole book, and I know it's a lot longer than most of you are even going to want to read, but I'll let you read just the first sentence and the last sentence of each paragraph. And if you can understand it and you can put your report together, then you can do it that way. And from that point on, I remembered if you can logically connect paragraph to paragraph from whether it's the first sentence and the conclusion to the next first sentence of the next paragraph, and you can catch exactly what you're trying to say, then you've successfully used transitions. You've been able to convey it in a way that's not so staccato of, I'm on this bumpy road. Where is this actually going? To a cohesive brief.
It links one paragraph to the next, so
Yeah,
they don't feel like they're standalone.
that's right.
The next tip is use clear and specific headings. This will help you preview, allow the reader to preview the structure clearly. Tell us more what that means about the importance of using clear and specific headings.
Yeah, with that tip, what I was thinking of when I wrote that, which I don't remember when I wrote it, but in so many briefs, I'm practicing in district court a lot, but still in so many briefs, you just see cause of action number one or argument number one. And there's no type of advocacy in the heading. And so it goes kind of back to that same point of if I can look at each one of your headings, and I know Chris Shandoval also has a post out there somewhere on this, and I
The
can
brief writing
see
ninja.
that's right, yeah. If I can see each of your arguments just in the headings, then I'm going to be able to jump into the paragraph and have a lot more understanding than trying to figure out what are they arguing about here.
I wonder if you agree with my approach in writing the headings for the statement of facts or statement of the case. Is I always like to start every heading with the month and year, or if applicable, the specific date, because I like to give the court or the reader a chronology within my statement of facts and statement of the case, so they know exactly what happened when, the relative time distance between each of the main events. Because otherwise, I feel like I always want to know what the chronology is personally as a reader, and I'm always annoyed when I have to delve into the actual prose of the subsections to find out when something happened.
That,
What do
that
you think about that approach?
that's funny, Tim, because when my associates bring me a brief that have any dates in the headlines, in the headings, I take a red pen and I ruthlessly remove all dates unless there's a statute of limitations issue. And I do headings in order, the accident, the recovery, the trial. But yeah, dates, boy, snoozeville. But what do you think, Patrick?
I'd probably lean more towards Jeff's approach in that if headings, I mean, if dates aren't going towards the argument, like this is a breach of contract case and they had to do something by X date and they didn't do it by that date, then I'm going to be putting in a lot of dates because dates matter. But if it's not an argument that's specific to a timeline, but it's specific to something else, I'll probably do in 2022, X happened. And I'll still put a date in there to guide the reader as to generally when something happened. Or I could say in August of 2025, but I don't have to say on August 22nd, 2025, Patrick Hagen spoke with Jeff and Tim on their podcast. But maybe that's coming from a different perspective in that I don't write as many appellate briefs, and I'm more on the trial side.
Well, Jeff's written more appellate briefs than I have. It's possible I just have a personal bias in terms of wanting to know when things happened, and maybe I would second guess the writer, that maybe the writer is overlooking an important chronological issue, and but I, as the reader, still want to know what those dates are. But that could be me. I'm in the minority in this company. So the next tip is next of Patrick Hagen's tips is watch for legalese. Instead, use simpler language when possible. I think this is self-explanatory, but say a few more words about why we should avoid using legalese.
Yeah, again, that goes back to the two judges I clerked for and how they were able to take such complex ideas and make them into simple concepts that the everyday reader could understand. And so a lot of the time I'm dealing with judges who are very sharp, who they could handle a lot of legalese, but just because a judge can handle it doesn't mean they enjoy reading legalese. And so I avoid legalese unless, again, you have an issue that requires you to say a certain legal phrase. But otherwise, if it's not necessary, then you're just adding more density to a brief that could be simpler.
Let's see, and then you had also offered some guidance for using ChatGPT effectively, which we talked about a little bit earlier. You said that we should avoid using ChatGPT for legal research, but do ask ChatGPT to rewrite sentences in plain English, which I think is a great idea. You mentioned doing that, trying that for some of your posts, but I think that's a winning idea for attorneys after they've written something, especially when you're really close to the case. And hey, it makes sense to me because I've been living this case. Put into ChatGPT and see if it can make it a little bit simpler than you have otherwise made it. When you and when you're living the case, anything about it makes sense to you.
That's right. Yeah. Yeah, you can almost use it as a third party that can look at it and say this doesn't make sense or this does. But yeah, it's a great tool to be able to put in a sentence or a very complex idea and have it symbolize it.
What have you gotten in general from the comments to your to all your LinkedIn posts? You've got 36,000 plus followers. I haven't counted how many posts there have been. Hundreds, I'm sure, maybe over 1,000 posts.
There have
Uh,
been a lot of posts. I'm not sure either.
and and they all get just an amazing amount of engagement. There's just dozens and dozens of comments to almost every single one of your posts. Have you learned things from your comments or been struck by some of the comments? What are your takeaway in general from your audience on LinkedIn?
I have sometimes I'd write a legal writing post that I felt strongly about, and then I'd get a bunch of comments, and then I'd ultimately comment on the post myself and say, so and so is right. This probably is a better way than what I just suggested in this post. So I can be humble and recognize that I'm not the legal writing ninja like some people. I still have training before I'm a ninja. Uh, but yeah, so with LinkedIn, you have lawyers who are very opinionated. And so just my quick LinkedIn tip for anyone who's thinking about starting to post on LinkedIn is one, you have to take a side. So pick a side. If you post a very neutral tip, it's not going to get any traction. It kind of goes back to your Reddit comment, right? That someone wants to point out something's wrong, or they want to point out why they believe one side is right, or they want to point out why they believe one side is wrong. Maybe a great example of this is one space versus two spaces after a period, which for years, because the judges I clerked for used two spaces after a period, that's what I did as well. And so I found a lot of people wanted to talk about that on LinkedIn because it really split the legal community. It's the big important things, you know.
Yeah.
But yeah, I do learn from the comments, and often my other small LinkedIn tip here is if you are going to post something on LinkedIn, be prepared to engage with the comments within the first 30 minutes. You might not have to spend a whole 30 minutes on there, but think of it like a snowball. It starts small, and once it starts rolling down the hill, once I get a first comment and I respond to that comment, and then that happens again and again, the snowball is going to ultimately just go on its own Like I posted something this morning and I haven't looked at it for hours, and checked on it a minute ago and it has like 175 likes and a bunch of comments now because people are commenting to each other, talking to each other in the comments, and so it can be a lot of fun.
Yeah. Yeah, that's the way the algorithms reward you is they see a lot of engagement and they say, "Hey, this is hot stuff that all of
That's
our
right.
readers need to know about."
Yes.
Yeah, so that is advice I've heard from SEO professionals as well, is that you should really babysit that post for the first 30 minutes, because if it starts getting engagement immediately and you can push that along by commenting on others' comments, then yeah, that's a way to get the snowball rolling down the hill.
Definitely.
You mentioned a little bit earlier about we attorneys sit as intermediaries between the client and the court. I wonder if you have any thoughts on how we as the attorney can do our best work and feel good about every case, even though in litigation it's binary. Some we're going to win and some we're just going to lose. And I like to think that that my contribution was valuable, even on the cases where we don't bring back the W, and that good writing is its own reward. Even though the client just wants to win, the client's not going to really care, are they, if we put together a real beautifully written brief if it didn't win. How can clients see the value of in our advocacy, our quality civil advocacy, even when it doesn't yield the desired result?
Yeah, as you mentioned, clients hire you for outcomes. And so they want to see the win. And if it's not a win, then it's a loss. But along the way, good advocacy builds trust with the client. It builds trust to show them that you're not putting typos in your brief. And it builds trust to show you that the court is going to take your argument seriously. So although we don't inherit the facts in any of our cases, some, oh, this is a great case. This is great facts. Others, you can kind of tell when it might be a loser, but you still have to present it in a way to the court that's clear, coherent, that the court can understand. And no matter the outcome, you have to be able to stand behind your brief and say, this is the best possible argument we could have made and representation we could have made to the court. So you have to make it difficult for the court in those cases where your facts aren't great. Because if you're not writing in a way that the court's going to want to rule for you, then you're already at a loss.
Yeah. Yeah, I like that. You should make it, in the cases where you should win, even where you don't win, at least you can come away thinking that, well, that judge must feel bad about himself because that judge really
That's
should have
right.
agreed with me.
That's the goal. Make judges feel
That's
bad about themselves. You can, and I
that's the
quote.
That's right. Okay, last question. Off duty, what are you reading when you're not reading legal briefs? Do you have, personal favorites, favorite authors, literary, legal, or otherwise?
So, as you know, as busy attorneys, we read so much during our workday that by the time I get home, have dinner with the kids and put the kids to bed, the only excellent source of reading material that I've read that night is something like the Bernstein Bears. So I have a 7-year-old, 5-year-old, 3-year-old, and a 1-year-old. And so that's about the extent of my reading for fun is children's books. But with that said, it gives you a great insight into what great writing can be. It's storytelling. It's writing it in a simple way. I know I've said the word simple and clear, although we're not going to say clearly in the brief a lot this podcast, but you want to convey a story that is so simple that a kid could potentially understand it.
Well, I got a book recommendation for you and your kids. If you haven't read Louis Sachar, if you
Okay.
remember the Disney movie Holes from about 20 years ago, Shia LaBeouf
Yeah.
was in it. Louis Sachar wrote the book, and he's also written a couple other. His best series, I think, is called Sideways Stories from Wayside School. Your kids will get a kick out of it. It's about a school who it was supposed to be 30 classrooms on one story, but the builder built it 30 stories tall with one classroom on each story. And the builder said he was very sorry. That's how the book starts. But it's all about
Nice.
adventures on the classroom on the 30th floor.
Very cool.
It's quite whimsical and well written. All right. Well, since we have a legal writing expert on the podcast, Jeff, we have to subject him to the lightning round.
Yeah, otherwise I'll get hate mail from France. So yeah, if whenever we don't do a lightning round. So all right, this is the time for our patented copyrighted segment of the show that answers the most pressing questions that vex appellate nerds around the world. The dreaded lightning round. Looking for short responses, one sentence if you can. Keep
Okay.
it simple. I know you know simple. Here we go. Important topics here. Font preference, Century Schoolbook, Garamond, or something else.
TNR 12.
I'm sorry.
Times New Roman 12.
Oh my God. I
Yeah, do we not
I
even
thought
have
that's what I
times
heard.
on the among our options?
And I
Sorry,
know
you're gonna have to pick again, Patrick.
this doesn't count towards the lightning round, but if I had a personal preference, it'd be Arial, which is one of the most controversial legal writing things I can say. I know.
Wow.
It's
Okay.
fairly controversial.
We
It
might
it,
have to
it
have you come back on a separate episode just to discuss font choice. But
Just
all
on
right.
fonts.
I think I know the answer, but two spaces or one.
I become one.
All right. All right.
a convert. Okay.
Oxford comma.
Of course.
Uh, here in California, the lower courts, we call them the Superior Court. I know you deal a lot with District Court, but when referring to the lower court, do you write Superior Court in caps with SC or District Court in caps with DC, or do you just do lowercase when referring to the lower court?
If I'm referring to the court I'm in front of, I do
Initial
uppercase.
caps. Yeah.
Yeah.
What is the name of your trial court in Florida?
Trial court, circuit court.
Circuit
Okay.
Court. All right.
Yeah. Which I know is confusing because there's appellate courts called circuit in other states.
Yeah. All right. Headings. All caps, initial caps, or sentence case.
I'm ashamed. The main first heading of the brief, all caps. The rest of them, sentence case.
Oh, okay.
Yeah.
That's acceptable.
Oh, I skipped one. This is Tim's favorite. Pled or pleaded?
What? I have a
Pled.
post on that one.
Um, when using initial caps, do you capitalize all words or just those under 4 letters?
I think it doesn't use initial caps,
Yeah, I'm not.
right?
I'm a sentence
Oh,
case guy.
all right, all right.
Yeah.
Left justify or full justify?
Full.
All right. And Tim, you cut me off when you had enough lightning. Possessives, Congress apostrophe or Congresses with an apostrophe between S's.
Apostrophe between S's.
All right. Uh, I don't even understand this one. You must have added this, Tim. Spaces between the periods and an ellipsis, or no spaces, dot, 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 or dot, space, dot.
Dot space. Dot space.
Okay. And I'm not sure I have an answer for that one. And after major headings in a brief, do you start the next section on a brand new page or you continue immediately below?
If there's not much space, I'll start it on the next page. I don't want to leave any widows and orphans out there. That's what I'll say.
Right.
Yeah. The brief writing ninja has some pretty strong advice on that.
He does.
That's next level. I haven't gotten there yet.
Is he a next page kind of a guy, or in terms of
Yeah, he'll strategically write just to bump things to the next page.
Okay.
Mhm.
All right. M dash with an M or N dash with an N? Which do you prefer?
They're two different things.
Oh, is there a post on that? I have to catch that one.
Yeah, I think you put that. All right, last one. Here we go. This is the most controversial of them all, and there is only one correct answer. Cleaned up? Use cleaned up in your briefs?
Not much.
Not much. All right, we're
How much,
hedging.
but you have done so?
What is
Admittedly, I've cleaned up, but I found that judges don't love it, so I don't use it often.
when one follow-up. What is your criteria when you decide, hey, I'm going to use it or not? Is it based on the judge you're in front of, or just whether or not it reads well? What's your criteria if this is a good candidate for cleaned up or not?
If the judge is using cleaned up, I'm happy to use cleaned up, but I found that it often just creates more work for the judge. They see cleaned up and they say, okay, how much cleaning did this person do? So if you're not establishing trust in your citations, then you're losing it.
Got it. All right. Well, You did pretty well. I don't know what your score was, but I think you survived our dreaded
It
lightning
wasn't quite
round.
lightning, so I apologize for that.
Yeah. As a reward for your well thought out and simple answers, and despite your adherence to Times New Roman, we are going to go ahead and send you a podcast mug as a thank you for coming on the show.
Looking forward to it.
All right. Well, thank you so much, Patrick Hagen. If our listeners have not yet subscribed and followed Patrick Hagen on LinkedIn, they must do so now as a precondition to continuing to listen to our podcast. But that's going to wrap up this episode, Jeff. If you have suggestions for future episodes, please email us at info@calpodcast.com. And our upcoming episodes look for tips on how to lay the groundwork for an appeal when preparing for trial.
See you next time.
Thanks.